what law applies? I'm often fond of saying, because I've written it in probably 1,000 briefs, that the rights and obligations of the FDIC are determined pursuant to federal law. It's what the statute says, it's what the cases say. That has evolved, or the source of federal law and the determination of federal law has evolved substantially over the past 25 years or so. Clearly, federal statutes apply with respect to the rights and obligations of the FDIC. But we were fond of arguing maybe 20 years ago that if there was no federal law, then federal common law applied. And that's the prong of this issue that's been hotly contested and litigated over, like I said, the last maybe 15 years. And the Supreme Court's actually taken the issue up on two cases, in the O'Melveny case and in the Atherton case, and actually to some degree in Langley. What's come out of this is, yes, the FDIC's rights and obligations are determined under federal law. But the application of federal common law will really only be found to be appropriate if, in engaging in the old Kimball Foods analysis, the determination is made that there is a quote-unquote important federal interest at stake. So the argument on the agency's behalf will always be that this has some systemic issue that needs to be resolved on a nationwide basis. In other words, it would be unfair and inappropriate for us to have piecemeal litigation with respect to a certain issue, determined under the state law of one state one way and determined under the state law of another state another way. It's a pretty difficult threshold for the FDIC to meet, and it has been narrowed and limited over the years. So what that means is if there is no federal statute on point and state law would not frustrate important federal objectives, state law is basically going to be incorporated as a rule of decision with respect to that particular issue. So no statute, state law. If state law is consistent and doesn't disrupt federal expectations, state law will be applied. If not, the argument will be that we need the judiciary to craft a federal common law principle to be applied in this particular instance. Now, as a corollary to that, we talked a little bit earlier about 1823E and the Dench Doctrine. Obviously, federal law is embodied in 1823E, and Dennis went through the prongs, I believe, of 1823E, but perhaps we should do it just to be clear. What 1823E does is mandate that an agreement can't be used against the FDIC unless it meets certain criteria. And the criteria are that it's in writing, first. Second, that it was executed by the depository institution and any person claiming an adverse interest thereunder, including the obligor, contemporaneously with the acquisition of the asset by the depository institution. And those of you who want to read along, I'm reading from page 20 of our outline. 3, was approved by the board of directors of the depository institution or its loan committee, which approval shall be reflected in the minutes of said board or committee. And 4, has been continuously from the time of its execution an official record of the depository institution. In other words, it's pretty much clear-cut that it's got to be in writing and it's got to be in the books and records, and it had to be in the books and records at the time it was made. That's what 1823E says. 1823E was used, or let me back up, and 1823E was susceptible to an argument prior to the passage of FIREA that it only applied to the FDIC in its corporate capacity because it didn't deal with receiver issues. We fixed that in FIREA by a provision in 1821 that says no claim against the receiver will be valid unless it meets the same requirements that are outlined in 1823E. So 1823E applies across the board to any claim or defense asserted by or against the FDIC. I talked a little bit earlier about the Dench Doctrine. The Dench Doctrine is a federal common law doctrine which many courts have said 1823E was generated from. At our time in the agency, we viewed those as two separate things. What Dench says is that agreements, secret agreements, I think is the word that the Supreme Court used in Dench, aren't enforceable against a financial institution because they're not part of the books and records and not available for inspection by examiners when the examiners examine the bank. In 1997, the FDIC came out with a policy statement of when it would apply 1823E and when it would apply the Dench Doctrine. And we've cited the policy statement, and if you're in any case where either of these issues come up, you need to read the policy statement because it defines the parameters that the agency sort of holds itself to in the assertion of these arguments. And it has taken the position, which was advocated by several courts of appeals, that 1823E is applicable in a certain set of circumstances and Dench is applicable in a different set of circumstances. And there is really no overlap between the two. There's no case where they'll argue both unless they're applying it to two separate issues that would be covered under the policy statement. I'm not going to go through the statement because, to be honest with you, you'll forget it by the time you walk out here, the rules that are applicable. And it's just something that if you're in a piece of litigation where Dench and 1823E are important, then get the policy statement out. Hold the FDIC to its policy statement. That's kind of the statutory rubric for federal court jurisdiction, removal, and the applicable law. They're a little dry. If you have any questions about that, chime in now. Otherwise, we're going to turn over to issues dealing with repudiation and enforcement of contracts, which are probably what's going to generate the most litigation in the time to come.